Title 2 on Conflict Resolution, Comparison of Customary Law, National Laws, and International Laws. What is customary law? Well, customary law is a set of customs, practices, and beliefs that are accepted as obligatory rules of conduct by indigenous peoples and local communities. Customary law forms an intrinsic part of their social and economic systems and way of life. The Talaandig custom law is referred to as batasan and was defined by Dr. Saway as the customary practices of the group deemed obligatory and specific to behavioral practices. According to their gugud or the historical myths, custom law originated from the conflict of two powerful deities during the time of creation, which eventually led to the separate order of creation. Thus, natural law was established between them and became the basis of the Talaandig custom law. These laws were then dictated to their ancestors to be taught to the people and followed for generations to come. In order to learn these custom laws, the history of the tribe is related to the young people and to those who are groomed to be leaders of the community. Moreover, they are encouraged to witness different rituals and the settling of disputes. The Andig capacity to understand the conflict is very unique. It practices the common sense approach. One basic approach of the Talaandig people to prevent conflict is common sense. Recognizing and understanding conflict does not require a master's degree or a doctoral degree. In order to utilize the common sense capacity in dealing with conflict, every person must simply know how to think, to listen, to see, to speak, to smell, to taste, to move, to touch, and to feel the conflict. Based on the common sense framework, concepts, ideas, philosophies, and principles are developed as tools in preventing conflicts through the use of the human senses, such as hearing, seeing, smelling, tasting, feeling, and touching. The Talandi people have developed mechanisms to prevent conflict based on models or framework known as the agpangan or patterns. Conflicts usually result from harsh environment. In preventing the conflict, the Talaandig people use patterns or models like a big rock against the strong current of the river or a big mountain against the strong wind or the shade of a big tree against the heat of the sun. By using these environment models, the Talaandig people developed the concept of the wall and the roof to prevent cold or to hide against the enemy. At the community, the wall can be extended to become a fort or a fence. The concept of the wall developed into traps like the door of a secured house. Furthermore, it developed into human defense forces in the community. The concept of the wall can be moved around, such as the shields of the warriors. The Talaandigs also practice the principle and concept of preventing conflict, such as the principle of interconnectedness and interdependency, wherein good and evil are interconnected. It is like the table full of food and the toilet, like the most intelligent brain in the anus, the most beautiful city and its garbage, or the delicious fish and its bones. Good and bad are inseparable and both need space and time to prevent conflict. This concept of interconnectedness of good and evil is like the interconnectedness of the parts of the body. For instance, the eyes, the hands, the heart of the brain is the heart, and the feet of the mouth are the feet. The ears of the nose are the ears, and the anus of the heart is the anus. The parts of the body are interdependent like the elements of the planet. Through the principle of interdependency and interconnectedness, the Talaandig always remember not to isolate the bad from the good. Rather, the Talaandig thinks on how space could be provided or put up a bridge to develop a good relationship between good and evil. The concept of balance and harmony between good and evil. The Talaandig people believe that the power of good and evil are perfectly equal. Neither good nor evil power can dominate the other. Based on the concept of balance, conflict between good and evil can be prevented by sustaining the balance and harmony between them. Good and evil represent the concept of the positive and negative, like the weak and the strong, the good and the bad, the man and the woman, the child and the adult person. Good and evil are not opponents. A conflict occurs when the balance is altered, and it can result to action or movement that either turn around or move forward or backward, like the rowing of a boat with outriggers at the right and left sides. To prevent a conflict, the movements must be properly coordinated and harmonized. The Talaandigs also believe in the concept of equality of God's creation. According to the Talaandig story of creation, when God created the world, He divided everything equally among tribes and nations. So, every human race got their fair share of the earth, the waters, the forests, mountains, the air, and sunlight. Everybody got their own share of faith, language or knowledge systems, laws, economy, weapon of security, prestige, power, and wealth. Conflict, therefore, can be prevented by recognizing, respecting, and protecting other people's share of creation. Conflict can be prevented too by further avoiding intrusion, invasion, stealing, and exploitation of other people's share of the world. The Talandig concept of justice is derived from the idea of the gantangan or the measuring box and the timbangan or the weighing scale that are used as basis in determining what is just and enough. In order to prevent conflict, every person or society must understand and learn what is enough and just for oneself. Another principle is the principle of avoidance and the principle of the wall and the shield. The elders of the Talaandig community, they say that you do not get yourself connected to things you do not desire. If you do not want to get wet, do not walk under the rain. The principle of avoidance is supplemented by the principle of the wall and the shield, with our elders saying that it is not good to build a roof when it is already raining. This means that conflict prevention had to be done ahead of time. Furthermore, it is also when we can still walk under the rain, provided that we have something to cover our head. The Talandic also believe in the spiritual means of preventing conflict, such as establishing a boundary or limit against the conflict. The Talandic people have religious or spiritual means done through a ritual called the pamalabag or pamagsa, meaning to define a boundary or limit. The Talaandig people believe that good and evil spirits have directors and leaders. War spirits, for example, inspire warriors according to the order and direction of their leader. To prevent war, the pamalabag or pamagsa ritual is performed. Through food offerings, the head of the war spirits is requested to recognize a boundary or limit that is created during the ritual. The Talandig people believe that war spirits can cause war or conflict only with justice. During the pamalabag or pamagsa ritual, the accountabilities of the community to the spirits of creation are settled symbolically. Social means of preventing conflict by the Talaandig through oral traditions and the laws on kinship. The social means of the Talaandig people in preventing conflict is through oral traditions. Another means to prevent conflict is accounting of genealogical relationships. Education and information about customary laws are also means of preventing conflicts in the society. During marriage arrangement, for example, the bride and the groom are warned against fighting or quarreling in-laws. The parents of a married couple are also warned not to quarrel based on the belief that they would suffer a curse from the spirits. On the laws on kinship, conflicts among the tribes in Mindanao are further prevented through the observance of the laws on kinship and brotherhood. These laws include number 1, the Kalalaha Abatasan, the law on mutual recognition, Number 2, the Sayuda Habatasan, the law on sharing of information. Number 3, the Buligaha Batasan, the law on cooperation. Number 4, the Uyagaha Batasan, or the law on mutual protection of life. And number 5, the Papatunbatunaha Batasan, the law on mutual assistance and help. The political means of preventing conflict by the Talaandig people also include peace-pact traditions, traditional alliance, and traditional defense systems. In the Talaandig community, a peace-pact tradition known as Tampuda Hubalagan or the cutting of the Ratan have prevented conflicts between the Talaandig people and the neighboring tribes such as the Manobo, Maranao, and Maguindanao communities. The Tampuda Hubalagan ceremony installed alliance and brotherhood among the Talaandig, Maranao, Maguindanao, and Manobo people and settled their conflicts regarding territorial boundaries, resource utilization in their ancestral lands. During the ceremony, restitution of damages known as banguna or the substitution of death and haphapugahinawa, touch to the heart, are executed. Intermarriage among the tribes is also performed to restore relationship by consanguinity. Another means of Talaandig people in preventing conflicts is established through the traditional alliance system called Kagsakulu. A sakulu or an ally has moral, social, political, spiritual, and economic obligation. If there is a conflict, a sakulu will come for support either to prevent, arbitrate, or to attack. Another prevention of conflict through the organization of human defense forces, such as the Alimao or the lions and the Bagani or the warriors, is taken from the concept of the wall and the shield. In order to prevent the dwellers of a house from conflicts, a wall must be established. Warriors as defense forces are human walls. They can be extended to a particular boundary like a fence or a fort, and they can move around with walls by bringing shields to prevent conflicts. There are also economic means of preventing conflicts, such as the food for peace. In the Talaandig community, there is food for peace as there is food for war. Food that people eat does not only provide them energy and strength, but also influence their behavior. Like drugs, food must be properly prescribed. According to our elders, people who eat stolen food will steal. Food that is produced from conflicts will, when eaten, will also cause conflicts. Food taken from corruption will also breed corruption. In order to produce food for peace, a farmer must understand the peaceful and harmonious relationships among plants. Plants also help protect or fight against each other. Plants also invade and exploit each other. Eating food that is produced from the harmonious and peaceful relationship of plants help prevent conflict. Approaches in conflict prevention include parental leadership, leadership accountability approach, and the culture impact assessment. Leaders who assume the parental leadership system are parents of every member of the community. The Talaandig concept of parents as the foundation and the source of the incoming generation means that good, fair, and just kind of leadership are provided by them. People who are corrupt, greedy, exploitative, disrespectful, and wary are born from parents who are of the same breed as people, who are respectful, trustworthy, just, and kind to others are product of good parental leadership. In order to prevent conflict, parents must be parents of good people. Individuals who want to become parents therefore must be given enough orientation on the role of the parents in conflict prevention. Leaders who are accountable to the attitudes, behavior, and norms of the community are also custodians of the people, the community, and its territory. The attitudes and behavior of the members of a community reflect the kind of leadership that they perform in the community. In order to prevent conflict, leaders must therefore consistently evaluate their programs and activities in the community. The Culture Impact Assessment or CIA system is an important means to prevent conflict. It is a tool used by the Talaandig people in assessing and evaluating the impact of their relationships with the outside world. The Cultural Impact Assessment System serves as a safety net to avoid the conflict of and incoming relations. Cultural Impact Assessment utilizes the Cultural Integrity Framework and the Territorial Integrity Framework in the assessment and evaluation process. Settlement and resolution of conflicts. Among the Talaandig, conflicts or disputes occur when custom law or customary practices are violated and or the person's rights have been infringed upon, such as murder, oral defamation, and etc. These conflicts are settled through batasan or custom law, executed under two general laws, the Lagitip Habatasan and the Saungangin Habatasan. The Lagitip Habatasan, which emphasizes the payment of a large amount of goods before the resolution of a conflict is made. This was formulated by the early datos to prevent the ordinary Talaandig from marrying a member of a datos family. Today, this law serves as a basis for settling other cases wherein the datos or tribal council demand a specified amount of goods as payment for their services or as means of penalty. The Saungangan Batasan was a law used to settle conflicts but demanding lower penalties according to the degree of batasan. In resolution of conflict, the Talaandig Datos do not generally permit anyone without authority to settle disputes in the community except when family squabbles arise, which can be arbitrated by parents or relatives. However, serious family problems are referred to the Datos for the gravity of the problem, especially if no part of the batasan has been violated. If a batasan has been violated, appropriate payment is demanded from the offender. Right to retaliate by the offended party without consulting the dato is permitted. It is possible if the case has not been endorsed to the dato for settlement. The offended group is given some time, such as in the case of murder and adultery. The time to retaliate is 8 days. Any extension of this limit is liable for punishment. The common cases of conflict within the Talaandig community besides murder and adultery are theft, slander, and oral defamation. The process of resolving these cases usually starts with the dato observing the batasan. He brings with him a white chicken for a ritual and gives the chicken to a dato within the council. Those to whom the chicken was given are expected to participate in the settlement and should not refuse. The offense will then be compensated by the performance of the ritual. The Talaandig datos follow a certain system of justice. Every conflict, before its resolution, must be investigated first in order to determine the truth. That dato must possess an ability or extraordinary skill in categorizing the facts and evidences. This is done because there are other offenses which are justifiable, such as self-defense. In the absence of malice to commit an offense, there is a possibility of pardon, for instance, to forgive and forget. Moreover, the goal in the settlement is to conciliate and to bring back the warring parties into a sound relationship. Like the other tribal groups, the Talaandig practice trial by ordeal, which is referred to as balaon. One example of this is the hot water ordeal, where the accused is told to obtain a needle from the bottom of a container filled with boiling water. This is done to determine the guilt of a person in such cases as theft and murder. There are also agreements with other tribes or pacts between the Talaandi groups and the other communities as well. In the Talaandig area, there are 5 tulugan or tribal communities with different leaders. They meet frequently, not only when problems arise, but also to discuss plans of how to strengthen their unity. All the datos in Bukidnon have agreed on a certain batasan. They are united and cohesive because they have kept to their traditions and practices. Those members of the groups or tribal communities which have entered into a pact are expected to abide by the rules. Failure to follow these precepts means punishment by the leader of the community depending on the degree of his offense. For instance, if a lumad from other tribal community enters into another community and abuses one of the members, the datu of the community where the intruder came from will be summoned to apprehend his offending constituent. This datu will then ask for some objects from the offender as a sign of repentance and seeking forgiveness. The datu will then ask for an apology from the datu whose member was abused. There is a standard of justice and role of people in settlements. In the settlement of disputes, the people in the community can influence the decisions of the datu or the tribal council. Since people can serve as witnesses and testify, evidences and testimonies may well affect the decision. Moreover, the people's opinion can be useful as basis for punishment or penalty, such as isolating the offender and banishing him from the community. The Talandig uphold a certain standard of justice in every case that is settled. That is why there is a need for a thorough investigation to every case or problem endorsed to the datu. The judgment or implemented by the datu is always included by the Talaandig Batasan. They strongly believe that a decision made by the datu or tribal council is with the approval of Magbabaya or the supreme god. According to the datu informants, all of the cases they have resolved in the past and even recently have not received any reactions or complaints from the accused and the offended parties. Tribal Council in Conflict Resolution. According to the data informants, all of the cases they have resolved in the past and even recently have not received any reactions or complaints from the accused and the offended parties. The datos recognize the fact that they could sometimes be susceptible to commit errors in their decisions. This is the reason why the tribal council is always there to assist. For every case settled by the Council, a report is to be submitted to the members of the Executive Committee. If there has been an error in the decision or judgment imposed on the accused, such as that he was declared innocent or the penalty was too heavy for such a light offense, the offending party whose guilt was not wholly declared will then become sick. This will motivate him to accept his guilt. For those mispenalized, the dato will make a readjustment to suit the degree of his offense. The dato who commits a mistake in the settlement of a case is subject to sanctions, likewise imposed on him, depending on, of course, the type of the case settled. If the error was unintentional, it can be reflected by offering a chicken. If misjudgment happened after he is given a chance to reform, he loses his authority as a dato and is stripped of all his functions and roles. This is the reconciliation and unity ritual of Bukidnon indigenous peoples that happened on November 28, 2013. The Talandig situation at present is very much akin or similar to the Manobo and Mamanoa in terms of the relationship with the non-Lumads who have settled in the Talandig areas for quite some time. Now and then, conflicts have arisen between the Talandig and the non-Lumads. Specifically, common conflicts concern on land, such as squatting or grabbing Talandig land, physical injuries caused by non-lumads, the murder of a lumad by a non-lumad, and vice versa, and theft perpetrated by both lumad and non-lumad. When a conflict arises and it is caused by a non-lumad, it usually referred to the barangay captain, following the rules of barangay justice for settlement. However, such cases as robbery and land grabbing are immediately endorsed to the local courts, specifically or especially if the degree of offense is quite serious and affecting a good number of persons. There are instances, however, wherein the barangay justice is used in a tribal community, especially when a non-lumad is involved. One of the dato informants related that he used it in some cases wherein the offender was a Talaandig and the victim was a non-lumad. However, he did not disregard their own batasan, but rather he integrated it into the barangay justice system. This is the indigenous culture system, the principle of life practiced by the Talaandig people of Sungko, Lantapan, Bukidnon, wherein life is the center and the culture and identity of the people being the center of all the indigenous beliefs in spirituality, the indigenous knowledge system, language and history, the indigenous health systems and medicine, the defense and security, the indigenous economy, and the customary governance and leadership, all being intertwined and interrelated with each other. Conflict prevention exists in every culture. It is just like the hands or the arms that are present in every human body. If society and culture is given recognition and support in preventing the conflicts in their own society, conflict prevention will not become a global issue. Conflict prevention can be resolved using the existing models of balance and harmony of creation. Much more, it can be resolved by preventing further invasion and intrusion of others' rights, cultures, and territories, as defined according to the equality of God's creation. Finally, conflict prevention can be more effective and practical through the use of common sense. It can be achieved locally and globally by letting the arms of peace in every culture hold together for the prevention of conflict in the world. Moving on to the Philippine laws on conflict resolution and alternative dispute resolution. Preface to Alternative Dispute Resolution Policy. As the court system has become more congested over the years by the increasing number of cases filed for litigation, the move for more and more cases to settlements through various alternative dispute resolution programs has been the government's thrust to the enactment of Republic Act number 9285 on April 2, 2004. This aims to promote party autonomy in the resolution of disputes or the freedom of the party to make their own arrangements to resolve their disputes. It is an important means to achieve speedy and impartial justice and to declog court dockets such as As such, the state shall provide means for the use of ADR as an efficient tool and an alternative procedure for the resolution of appropriate cases. Arbitration, mediation, and consolation laws in the Philippines. These are the four laws and rules that govern mainly the arbitration in the Philippines, such as the Republic Act number 876 or the Arbitration Law, the RA number 9285 in 2004 known as the Alternative Dispute Resolution Act of 2004, and the Special ADR Rules promulgated by the Supreme Court on September 2009, as well as the Philippine Village Justice System governed by the Republic Act number 7160 or the Local Government Code of 1991. As an overview of the laws on arbitration, arbitration has traditionally been recognized as the common method of dispute resolution in the Philippines, stipulated in Articles 2028 to 2046 of the Philippine Civil Code. However, until the 1920s, the Philippine courts were not necessarily friendly to the arbitration system, as there were a number of cases wherein arbitration agreements between the parties were invalidated by the Philippine courts. In the 1950s, the Philippines began to be more open to the concept of arbitration, and in 1953, the Congress of the Philippines enacted Republic Act number 876 or the Arbitration Act. Later on, in June 10, 1958, the Philippines signed the New York Convention, which was ratified on July 6, 1967, aimed to promote the development of basic laws on arbitration. However, the arbitration law contains many ambiguities. For example, it does not set out the details of arbitration procedure. Also, it does not describe the method to enforce foreign arbitral awards and does not comply with the United Nations Commission on International Trade Model Law on International Arbitration or the UNCITRAL Model Law adopted on June 21, 1985. In 2004, about 50 years after the enactment of the Arbitration Act, the Congress enacted RA 9285, or the Alternative Dispute Resolution Act of 2004, or the ADR Act, which was based on the UNCITRAL Model Law. The ADR Act forms part of the core of the Philippine arbitration system, amending and supplementing the Arbitration Act. In addition, in 2010, the Special Rules on Alternative Dispute Resolution or the Special ADR Rules were enacted. It provides for a system whereby courts shall refer to or the parties to arbitration upon mutual consent. Lastly, the Philippine Barangay Justice System or Katarungang Pambarangay or the Barangay Justice System as a local justice system for dispute resolution in the Philippine barangays was also being practiced. Again, these are the rules or the laws governing arbitration, mediation, and conciliation. The Philippine Civil Code, the Arbitration Act, the ADR Act, the ADR Special Court Rules, and the Philippine Barangay Justice System or Katarungang Barangay. Of these, the ADR Act provides the foundation of the arbitration system. What is the RA number 876 or the Arbitration Act of 1953? This is the Republic Act known as the Arbitration Law of June 1953. This is an act to authorize the making of arbitration and submission of agreements, to provide for the appointment of arbitrators and the procedure for arbitration in civil controversies and for other purposes. This law was approved quite a long time ago in June 1953. The Alternative Dispute Resolution Law or Republic Act number 9285, otherwise known as the Alternative Dispute Resolution Act of 2014, merely amended certain parts of this act. In fact, most of its provisions still possess legal force and effect. The truth is that ADR law even refers to various provisions of the arbitration law. For instance, Section 32 of the ADR law points out that domestic arbitration shall continue to be governed by the provisions of the arbitration law. What are the restrictions and limitations of RA 9 number 876? Controversies in cases not subject to the provisions of the arbitration law are: number one, cases subject to the jurisdiction of the Court of Industrial Relations are not arbitrable under this law. Other labor-related disputes are likewise excluded from the ambit of this law. The Labor Code provides for different systems of grievance and arbitration resolution. RA number 876. These are the form of arbitration agreements. Number one, a contract reflecting the intent to arbitrate disputes shall be written and subscribed by the party sought to be charged or his lawful or authorized agent. A submission to arbitrate shall be written and subscribed by the party sought to be charged or his lawful or authorized agent. Number three, the making of a contract or submission expressing the parties' intent to submit their disputes to arbitration shall be deemed a consent of the same parties to the jurisdiction of the regional trial court, where any of the parties resides for the enforcement of the contract or submission. Number four, item 3 can be put in another way. It means that the making of the contract or the submission automatically confers the RTC, where any of the parties reside jurisdiction to enforce said contract or submission. Number 5, it would be null and void for the parties to stipulate that their disputes are to be considered immune from the jurisdiction of the courts. Number 6, amicable arrangements are looked upon with favor by the courts. And number 7, courts must be reluctant to interfere with the arbitration or cause the nullity thereof. The reason for this is that the law prefers the autonomy of the disputants. These are the preliminary procedures of RA number 876. Number 1, if there is an arbitration clause, service by either party upon the other of demand for arbitration shall institute the arbitration proceedings. Number 2, attached to the demand for arbitration shall be the nature of the controversy, the amount involved, the relief sought, and the true copy of the contract. Number 3, demand may be served in person or through registered mail. Number 4, if the stipulation to appoint only one arbiter exists, the service shall also include the specific time within which the same shall be made. Number 5, if stipulation to appoint 3 arbiters exist or arbitrators exist, and one is to be selected by each party, the demand shall set forth the name of the arbitrator selected by the demanding party. If the demand shall also mention that the demanding party shall advise in writing and the demanding party of the name of the person appointed as the second arbitrator within 15 days. The notice of demand shall also set forth that the 2 chosen arbitrators shall make a selection of the third arbitrator within 10 days from the said notice. Number 8, arbitration proceedings shall likewise be instituted by filing with the clerk of court of the RTC having jurisdiction over the parties in the event that one party failed to answer the demand. Filing the COC shall be made with a copy of the demand for arbitration, and a notice of the original demand was sent by a registered mail or in person. Such filing with the COC shall be accompanied by the nature of the controversy, the amount involved, the relief sought, and the true copy of the contract. Number 9, submission of the existing controversy may be done by any party and shall be duly executed by both of the parties. And number 10, when one party neglects, fails, or refuses to arbitrate as stipulated in the contract, items 1 to 7 shall be followed. RA 9285, or the Alternative Dispute Resolution Act of 2004, known as the ADR Act of 2004. This is an act to institutionalize the use of an alternative dispute resolution system in the Philippines and to establish the Office for Alternative Dispute Resolution and for other purposes. The Republic Act No. 9285, also known as the ADR Act of 2004, was a significant piece of legislation because it was at the time of its passage the most comprehensive Philippine law on alternative dispute resolution. The ADR Act introduced the concept of international commercial arbitration and adopted the UNCITRAL model law as the law governing international commercial arbitration in the Philippines. It also provided the enabling legislation for the recognition and enforcement of foreign arbitral awards in the Philippines. With respect to domestic arbitration, The ADR Act amended the Arbitration Law or Republic Act number 876 to update its provisions so as to be more consistent with prevailing international practices in arbitration. The ADR is a means or any process or procedure used to resolve a dispute or controversy other than by adjudicating of a presiding judge or a court or an officer of government agency, as defined in this act, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, consolation, early neutral evaluation, mini-trial, or any combination thereof. What are the advantages of ADR? Arbitration has the following advantages. A. Speed, because arbitration proceedings are generally faster than court litigation. B. Cost efficiency, because there are ways to manage the cost of the arbitration proceedings. C. Flexibility, because parties are generally able to direct how the proceedings should be conducted. D. Ability of the parties to participate in the choice of arbitrator. E. Finality, because arbitral awards are generally not appealable on the merits. F. Confidentiality of the arbitration proceedings. G. Enforceability of the arbitral award. Alternative dispute resolution can take many different forms and can be used to help the parties negotiate to reach a mutually acceptable compromise, such as arbitration, mediation, conciliation, early neutral evaluation, mini-trial, or any combination thereof. What is arbitration? It means voluntary dispute resolution process in which one or more arbitrators appointed in accordance with the agreement of the parties or rules promulgated pursuant to this act resolve a dispute by rendering an award. Mediation is a voluntary process in which a mediator selected by the disputing parties facilitates communication, negotiation, and assists the parties in reaching a voluntary agreement regarding a dispute. Conciliation is a process whereby parties request a third person or persons as a conciliator to assist them in their attempt to reach an amicable settlement of their dispute arising out of or relating to a contractual or other legal relationship. The conciliator does not have the authority to impose upon the parties, though, a solution to the dispute. Early mutual evaluation. It is an ADR process wherein parties and their lawyers are brought together early in pre-trial phase to present summaries of their cases and receive a non-binding assessment by an experienced neutral person with expertise in the substance of the dispute. A mini-trial is a structured dispute resolution method wherein the merits of a case are argued before a panel composed of senior decision makers with or without the presence of a neutral third person, after which the parties seek negotiated settlement. Now, what are the most commonly used ADR forms? These are mediation and judicial dispute resolution conferences, which are being normally conducted before the proper trial begins. Question: what are the requirements for ADR? In both civil and criminal cases, mediation and judicial dispute resolution conferences are ADR methods that parties to a case must undergo during the proceedings or before the trial begins. In criminal cases, only the civil aspect of the claim can be subject of ADR proceedings. What is the place of arbitration? The parties are free to agree on the place of arbitration. Failing such agreement, the place of arbitration shall be in Metro Manila, as in Article 30 of the ADR Act. However, the arbitral tribunal may determine the place of arbitration and the place of the hearing. What may be the language of arbitration? The parties are free to set or agree on the language or languages to be used in the arbitral proceedings. Failing such agreement, the language to be used shall be English in international arbitration and English or Filipino for domestic arbitration, unless otherwise determined by the arbitral tribunal. RA 9285 as an interim measure for protection. Here, the parties may make a request for an interim measure of protection with the Philippine courts or arbitral tribunal before or simultaneously with filing an application for arbitral proceedings. Here are some comparisons between judicial processes and the various alternative dispute resolution processes. As to the adjudicatory process of the judicial process, whereas arbitration, mediation, and other ADR processes are decided by third parties, such as arbitrators, mediators, among others. For judicial process, procedures and decisions are controlled by provisions of relevant statutes, whereas arbitration, mediation, and others are controlled by specific laws such as the RA 876. In judicial process, the decision is binding on the parties. Arbitration, mediation, and others are also binding on the parties in terms of the awards. In judicial process, adversarial in nature, as its focus is on the past events and determination of rights and liabilities of the parties. Arbitration, mediation, and other ADR processes may be adversarial in nature or collaborative in nature. Some more comparisons between judicial process and various ADR processes as to personal appearance or active participation of the parties, as to formal proceedings be held in public and its procedural stages, as to the appealability of the decision, as to opportunities for the parties to communicate directly with each other, and as to involvement of payment of court fees. Here are the other comparisons between the other ADR or alternative dispute resolution processes such as mediation, conciliation, early neutral evaluation, and mini trial. With regard to being adjudicatory processes, being voluntary processes, having mediators, conciliators, presiding officers, and other neutral third parties as members of adjudication, having services of lawyers, availability, as to what is the center of the negotiation, as to the functions of the mediator, the conciliator, the office of presiding officer, or the mini trial panel members, and as to the consent of the parties, whether being mandatory or not. Also, these are the other comparisons between mediation, conciliation, early neutral evaluations, and mini trial, whether or not the decree or order is appealable, whether the focus of the mediation, conciliation, early neutral evaluations, and mini trials are on the present or the future, or the past events, whether the structures of the processes have different stages or not, or whether the parties are actively or directly involved, or whether confidentiality as the essence of all these ADR procedures, and whether or not the assessment of the mediators, conciliators, neutral third persons, and panel members of the mini trial be binding upon the principal. Now let's proceed to the Special Rules of Court on Alternative Dispute Resolution, or the ADR Rules. The special ADR rules govern the various stages of court participation in arbitration proceedings. The challenge to the existence, validity, and enforceability of arbitration agreements, referral to arbitration, interim measures of protection, appointment, challenge, and termination of arbitrators, assistance in taking evidence, confidentiality of protective orders, confirmation, correction, or vacation of award in domestic arbitration, the recognition and enforcement or setting aside of an international commercial arbitration award, the recognition and enforcement of foreign arbitral awards and appeals to the Court of Appeals and the Supreme Court. The special ADR rules reiterate the state policy of promoting arbitration. It is the policy of the state to actively promote the use of various modes of ADR and to respect party autonomy or the freedom of the parties to make their own arrangements in the resolution of the disputes with the greatest cooperation of and the least intervention from the courts. The objectives of the special ADR rules are to encourage and promote the use of ADR, particularly arbitration and mediation, as an important means to achieve speedy and efficient resolution of disputes, impartial justice, curb a litigious culture, and to declog court dockets. The salient provisions of the special ADR rules. The following are some of the salient provisions of the special ADR rules. First, a party may challenge before the courts the existence, validity, and enforceability of an arbitration agreement. The challenge may be done either before or after the commencement of the arbitration. Next, despite the pendency of the petition for judicial determination of the existence, validity, and/or enforceability of an arbitration agreement, the arbitral proceedings may nevertheless be commenced and continue to the rendition of the award while the issue is pending before court. Next, in resolving the petition, the court must exercise judicial restraint, deferring as much as possible to the competence or jurisdiction of the arbitral tribunal to rule on its competence or jurisdiction. Another is a party to a pending action filed in violation of the arbitration agreement may request the court to refer the parties to arbitration in accordance with such agreement. The request for referral shall be made not later than pretrial conference. After the pretrial conference, the court will act upon the request for referral only if it is made with the agreement of all parties to the case. And despite the pendency of the court action, the arbitral proceedings may nevertheless be commenced or continued, and an award may be made while the action is pending before court. A petition for an interim measure of protection may also be made, A. Before arbitration is commenced, B. After arbitration is commenced but before the constitution of the arbitral tribunal, or C. After the constitution of the arbitral tribunal and at any time during arbitral proceedings, but at this stage only to the extent that the arbitral tribunal has no power to act or is unable to act effectively. The court shall also assist in the enforcement of an interim measure of protection issued by the arbitral tribunal, which it is unable. Moving on to the Philippine Barangay Justice System, or what we call the Katarungang Pambarangay. The relevant law governing this justice system is Republic Act number 7160, or the Local Government Code of 1991, Chapter 7, Sections 399 to 422. Under this Philippine Barangay Justice System, or Katarungang Pambarangay, this is a community-based dispute settlement mechanism that is facilitated by the barangay. It covers disputes within members of the same community wherein lawyers are not allowed. For cases that are covered by the Katarungang Pambarangay, it is compulsory for the parties to go through mediation and/or conciliation proceedings before going to court. Failure to do so would mean the dismissal of the party's claim or counterclaim. The Katarungang Pambarangay, or the Barangay Justice System, is a local justice system in the Philippines, operated by the smallest of the local government units, the barangay, and is overseen by the barangay captain, the highest elected official of the barangay, and its executive. The barangay captain sits on the Lupon Tagapamayapa along with the other barangay residents, which is the committee that decides disputes and other matters. They do not constitute a court as they do not have judicial powers. A lot of us may have overheard about the Lupon Tagapamayapa, but what is the Lupon Tagapamayapa? It is the body that comprises the barangay justice system, and on it sit the barangay captain along with 10 to 20 members. The body is normally constituted every 3 years, and it holds office until the new body is constituted in the third year. They receive no compensation except honoraria, allowances, and other no emoluments as authorized by the law or the barangay, the municipal, or city ordinance. Almost all civil disputes in many crimes with potential prison sentences of 1 year or less or fines of 5,000 pesos or less are subjected to the system. In barangays where a majority of the members belong to an indigenous people of the Philippines, traditional dispute mechanisms such as the Council of Elders may replace the barangay judicial system. The processes to constitute the Katarungang Pambarangay. First is the constitution of the Lupong Tagapamayapa or the Lupon. Second is the notice to constitute a Lupon. Third is the appointment and the posting. Fourth is the complaint or the filing of the complaint. The fifth is the mediation by the Lupon. Sixth is the constitution of the Pangkat Tagapamayapa or the Pangkat. The seventh is the conciliation for the Pangkat. And the eighth is the termination. There are exceptions from the barangay justice system, where one party is in the government, or any subdivision or instrumentality thereof, where one party is a public officer or employee, and the dispute relates to the performance of his official functions, where the offense is punishable by imprisonment exceeding 1 year or a fine exceeding 5,000 pesos, and offenses where there is no private offended party. Exceptions for the disputes that the Lupon cannot intervene is where the dispute involves real properties located in different cities or municipalities. For disputes also involving parties who actually reside in barangays of different cities or municipalities. For disputes also that need urgent legal action and where the accused is under detention. The venue of the barangay justice system should be first in the same barangay or the lupon of the said barangay. Number two, if different barangays but same city or municipality, the barangay where the respondent or any of the respondents actually resides at the election of the complainant. And third, if it's a real property, the barangay where the real property or the larger portion thereof is situated. In cases where there are different barangays and different cities or municipalities involved, there is no need to undergo barangay consolation proceedings, but the parties may still agree if in case there are adjoining cities or municipalities. And if the parties do not agree, they may go to court directly. For juridical entities or involving juridical entities, any case involving a corporation or juridical entity, they can go directly to court without going through the mediation or conciliation. Now, these are the processes before the lupon. First, the complainant files the complaint, either oral or written complaints. Second, there is a mediation by the lupon within 15 days. Third, if there is a failure to mediate, there will be a constitution of the pangkat. Fourth, if there is successful mediation, there will be a drafting and execution of the written settlement agreement. Now, it is very important that a certificate to file action shall be filled up, attesting that no conciliation or settlement has been reached as certified by the Pangkat Secretary and signed by the Pangkat Chairman. It shall also be submitted to the corresponding court or government office for the filing of the appropriate case whenever necessary. Now, arbitration is also a process that's done within the barangay justice system. The parties may agree in writing that they shall abide by the arbitration award of the lupon or pangkat. When can the parties have arbitration? At any stage of the proceedings. Either the lupon chairman or the pangkat chairperson can act as an arbitrator. Herein, the parties shall present evidence as to the facts and merits of the case to the arbitrator. And on the basis of these facts, the arbitrator makes a decision on what he or she believes to be fair and just. Arbitration process, the lupon chairman or pangkat chairman is given the power to render decisions on the dispute with a prior agreement of the parties that will be bound by it. The lupon chairman is then given 15 days, but not earlier than 6 days from the date of the last hearing to evaluate the case and issue the arbitration award. After that, the secretary shall furnish a copy of the arbitration award to the parties within 5 days. Again, going back to the laws governing arbitration, mediation, and conciliation as a recap, these are the following laws. First is the Philippine Civil Code. Second is the Arbitration Act. Third is the ADR or Alternative Dispute Resolution Act. Fourth is the ADR Special Court Rules. And fifth is the Philippine Barangay Justice System or the Katarungan Pambarangay. Of all these, the ADR Act provides the foundation of the arbitration system. Now let's proceed to the international laws on conflict resolution and alternative dispute resolution. This chapter studies dispute resolution mechanisms and their efficacy for resolving international conflicts and/or various conflicts happening globally. By consequence, international, cultural heritage, commercial, and trade disputes can be settled through non-judicial procedures, negotiation, mediation, conciliation, or arbitration, commonly referred to as ADR or Alternative Dispute Resolution means, or if these fail or are not available, through litigation before domestic courts or international courts. International ADR has increased dramatically in recent years with the emergence of complex mechanisms for resolving disputes between states and other actors, including international organizations, corporations, and persons. However, older mechanisms such as the ICJ or the International Court of Justice continue to play an important role in resolving key disputes. Here, we will delve more about non-adjudicatory procedures such as mediation, arbitration, and judicial settlement in international law. What is dispute resolution then? It is nothing but the process to resolve a conflict between two parties. Historically speaking, all methods of dispute resolution were judicial in nature. However, with time, alternative methods have caught up to the trend. Today, most of the disputes are resolved through one of these methods, which include arbitration, mediation, negotiation, conciliation, among others. If a satisfactory result does not yield out the methods mentioned above, then the last stop remains with litigation. Conflict resolution or dispute resolution may have various forms. It could be dispute amongst the individuals, dispute amongst employee and employer, or dispute amongst governments, or even nation-state. In all such situations, the parties to the dispute have a range of options to resolve the matter. They may choose to resolve it by themselves or with the help of private or government third party. If nothing works, then the last resort is, of course, solving the matter with the help of a formal court, or what we call these days litigation. With the growing demand for alternative dispute resolution, pressure in courts is reduced. Also, disputes can be very time-consuming and expensive at times. That's why even parties to the dispute find it more convenient to settle the matter outside the court. What is the scope of dispute resolution in international law? Well, dispute resolution plays a very important role in international law, as the latter was created with a purpose to maintain world peace and security. No one can stop war and violence, but when it is standing right at the front of your nation, and it becomes the primary concern to get out of it peacefully. During such hard times, nations at dispute agree to settle the matter and move forward. Alternative dispute resolution, being economical and time-saving, is the most preferred option. Hence, international disputes can be settled through non-judicial procedures, such as negotiation, mediation, conciliation, or arbitration, commonly referred to as ADR. And if this fail or are not available, litigation before domestic courts or international tribunals. Now, here are the different ADR resolution service that is offered in a systematic way to tackle the situation with harmony. We have diplomatic methods, which includes negotiation, mediation, conciliation, adjudicated methods. It includes arbitration, judicial settlement, among others, and the institutional methods, which include peaceful settlements with the help of international organizations. Historically, most cases of dispute resolution revolve around negotiations, mediation, or arbitration. However, these days, the pattern of new methods are also taken into consideration. As it is an important concern for international dispute settlement, many international diplomats, lawyers, and commentators aim to settle such matter through the means of dispute resolution. Of resolving international disputes or conflicts. First is a dispute resolution on legal and political disputes. There are two grounds on disagreement between two parties, either political or legal, and the distinction between the two can be purely subjective. It is primarily the attitude of the states that decide whether a dispute is a legal or a political one. Owing to the involvement of the states, it becomes difficult to distinguish the two. For a dispute to be regarded as a legal one, states must desire to settle it on the basis of law, or else it becomes a political dispute. However, the question arises whether the dispute of the state are legal or not, and such question is solved in accordance with what shall be settled by the decision of the court. Therefore, an international law dispute must be taken in a restricted sense, as that it does not concern all forms of dispute but only legal disputes. In international law, there have been two methods devised for settling such legal disputes. First is amicable or pacific means of settlement, and the coercive or compulsive means of settlement. The amicable means or the pacific means, which is basically part of the Charter of the United Nations, the objective of which, or the creation of the League of United Nations in 1999 and the United Nations in 1945, which particularly has been maintenance of the international peace and security. Various multilateral treaties have been concluded that aim for the peaceful settlement of disputes. One of the most important ones is the Hague Convention of 1899 for the peaceful settlement of disputes. The UN Charter provides that all international disputes must be settled by the member of peaceful means, while maintaining international peace, security, and ensuring justice is not endangered. It enumerates a number of means for the peaceful settlement of disputes. Could be through negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, or resort to regional agencies among the few choices. The United Nations Charter is the constitutive instrument of the United Nations signed on June 26, 1945, which sets out the rights and obligations of member states and establishes the principal organs and procedures of the UN. Its purpose is to set forth in the Charter, or to maintain international peace and security, to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples. The Hague Convention, on the other hand, is a series of international treaties that issued from international conferences held at The Hague in the Netherlands in 1899 and 1907. The major effort in both conferences was the creation of a binding international court for compulsory arbitration to settle international disputes, which was considered necessary to replace the institution of war. Last and most important was the adoption of the Convention for the Pacific Settlement of International Disputes, creating the Permanent Court of Arbitration. Among the governing bodies and conventions that also helped to settle international disputes was the Singapore Convention on Mediation, formerly the United Nations Convention on International Settlement Agreements, resulting from mediation, adopted on the 20th of December 2018 and opened for signature on August 7, 2019, which was an international agreement regarding the recognition of mediated settlements. This convention aims to address the lack of a process by which settlement agreements can easily be recognized and enforced internationally. Currently, such settlements have the status of contracts only and require further court proceedings to force compliance should one party fail to abide by the terms agreed. The UNICITRAL, or the United Nations Commission on International Trade Law model, actually has amendments as adopted in 2006 from the 1985 original model law. The model law is designed to assist states in reforming and modernizing their laws on arbitral procedures so as to take into account the particular features and needs of international commercial arbitration. The UNCITRAL model law provides a pattern that lawmakers in national governments such as the Philippines can adopt as part of their domestic legislation on arbitration. The UNCITRAL arbitration rules, on the other hand, are selected by the parties either as part of their contract or after a dispute arises to govern the conduct of an arbitration intended to resolve a dispute or disputes between themselves. Put simply, the UNCITRAL model law is directed at states, while the arbitration rules are directed at potential or actual parties to a dispute. Extrajudicial or peaceful means of settlement is also by a means of agreement between the two disputant parties. This method is also known as the political means or the diplomatic measures. Another is the negotiation, which is regarded as the oldest and the simplest form of settling disputes. When the disputant parties settle the dispute themselves by discussion or by adjusting the disagreement, the process is called a negotiation. The dictionary meaning of negotiation defines it as a discussion aimed at reaching an agreement. Hence, in the case of disagreement, the method of negotiation can be used to reach a state of peaceful agreement. This process may be carried out by the heads of the state or by the representatives or by diplomatic agents. But the success of this method depends largely upon the degree of acceptability of claims of one party by the other. However, it has certain weaknesses too, and on various occasions it has been seen that it becomes difficult to come to a consensus. Good offices and mediation. Mediation and good offices may come into picture when parties are not willing to go for the negotiation method or they fail to reach a state of settlement through a healthy negotiation. A third-party person assists them in solving their legal matters. Such a third person may either be appointed by the parties themselves or by the Security Council. There have been many instances where the appointment has been made by the Security Council and the views of the third party acquire the character of advice and by no means have a binding force. There are two ways of settling dispute by third party, either through good offices or mediation. Good offices is basically the act through which the third party either arranges for a meeting between the disputant parties or he acts in ways through which a peaceful settlement can be reached. It is important to note that the third party is not directly involved in this process, but when the parties have failed to come to terms through negotiation, it is the third party that provides for their good offices for peaceful settlement of disputes. And once the parties are brought under one roof, the third party has no active role to play. In mediation, there is a third party involved known as the mediator, who is always expected to be just and impartial. In the process of mediation, the mediator participates in the discussion, gives his views and suggestions in solving or resolving the dispute. The mediator is usually known to settle the disputes, as he may even help in signing the treaty embodying the settlement that is reached. Another form of ADR in the international ways is conciliation. This is the process where a commission or a committee is appointed and the dispute is referred to them, and it is required by them to find out about the facts and then to report for the settlement of the dispute. Here, the effort is made for a peaceful compromise to sign an agreement, but important to note that the proposals made the Commission are never binding on the parties to the dispute. This method is unique in its own way and completely differs from mediation, inquiry, or arbitration. Here, the proposals are made for settlement after finding facts about the dispute, but in mediation, the third party is part of the meetings with the parties in dispute. Also, it is not for the mediator to ascertain facts about the case, as opposed to conciliation. Such committees or commissions that provide for conciliation may either be permanent or ad hoc in nature, and the idea of the Conciliation Commission was born in 1899 and 1907 Hague Conventions for the Pacific settlement of disputes. Several treaties after the end of the First World War were made through the Conciliation Commission. The General Assembly under Article 10 and 14 and the Security Council under Article 34 has the power to appoint a commission to settle disputes. Among the various treaties that have been signed through the Conciliation Commission, the most important ones are the Pacific Settlement of 1948, the Pact of Bogota of 1948, and the Vienna Convention on Protection of the Ozone Layer. Another form of ADR in the international laws is inquiry. And one of the most common obstacles that prevent the successful settlement of disputes in international law is the ascertainment of the facts, as it has been observed for the years that different views are put forward by the disputant parties. A majority of the international disputes get stuck because of the unwillingness and inability of the parties to go and agree to the facts. The dictionary meaning of inquiry suggests that it is an act of asking for information, and similarly for settlement of disputes in international law, a commission is to be appointed consisting of honest and impartial investigators so that they can verify the facts of the issue. The sole function of this commission is known to be the ascertainment of issues. This procedure for the settlement of international disputes was born at the Hague Conference of 1899. It was said that the states who were not willing to end their disputes by agreement might use the process of inquiry. The inquiry consisted of a special agreement between the parties in dispute, and as it was truly special, as it enjoyed a wide range of powers ranging from examination of the facts, mode of investigation and examination, the time frame for the formation of a commission, the place where the commission will sit, and the language that it is to be used, or that is to be used, the extent of the powers of the commission as well. Hague was chosen to be the place where the commission would sit if the special agreement chose to remain silent on the place of the meeting. Another peaceful means of settlement of disputes is one of the principles of the United Nations provided under their charter. The General Assembly and Security Council are two organs of the United Nations that have been empowered to discharge functions regarding this. In 1982, a committee successfully drafted a declaration that was to be adopted by the Assembly, and this declaration was known as the Manila Declaration. It mentioned that the states shall seek any peaceful way of settlement of a dispute in good faith and a spirit of cooperation. It also mentioned that the states had absolute liberty to make full use of the United Nations. The United Nations General Assembly has not been empowered to settle the disputes using any specific means, but it holds a wide range of powers to do the same and discuss it. In simpler words, then, it can be said that the UN General Assembly holds the general power for the peaceful settlement of international disputes. In many various instances, the Assembly has suggested for a peaceful settlement of disputes. In 1974, it called upon the member states to make full use and seek improved implementation provided for in the UN Charter for exclusively settling peacefully any or all disputes or any situation. The Declaration on Prevention and Removal of Disputes was drafted by the Special Committee and was said to threaten international peace and security. However, this declaration is said to have been approved by the Assembly in the same year. And some of the important provisions of the declaration were the foreign ministers' level meetings to be held sometimes by the Security Council and the appointment of the Security or Secretary General as the rapporteur in a specific dispute must be considered by the Council, the fact-finding or good offices that should happen at an early stage, and the Secretary General must consider approaching the states concerned. The UN Security Council. The judicial settlement in the process of solving a dispute by the International Tribunal in accordance with the rules set by the international law must be understood as the expression of the International Tribunal. It acquires an international status because of its jurisdiction. At present day, the International Court of Justice, although not the only tribunal, but it is indeed the most important tribunal around the globe, there are also ad hoc tribunals and mixed commissions at present. And it is also important to note that the International Tribunal is different from the Municipal Tribunal. The International Tribunal applies international law, while the municipal laws are applied by Municipal Tribunal. And there are extents by which the internationals can be applied by the Municipal Tribunal, well, depending entirely on the relationship between the fields of law. Arbitration and settlement of disputes by international law have become two very important modes of settlement of disputes today. Similar to our national laws, international law of arbitration is also the process of using help, advice, and recommendation of a third party called the arbitrator to settle the disputes. As ILC defines it, it is a procedure for the settlement of disputes between states by a binding award on the basis of law and as a result of voluntarily accepted undertaking. It's a blend civil law procedure and common law procedure, and sometimes also referred to as a hybrid form of international dispute resolution. In the case of Qatar versus Bahrain, it stated that the word arbitration for the purpose of international law usually refers to settlement of disputes between states by judges of their own choice. The UN Security Council can also apply intervention by state in the affairs of another state as a recourse to the settlement of disputes. It is important to note that after the establishment of the United Nations, a state has been substantially prevented from taking compulsive actions to settle international disputes. Any measure that is likely to threaten or endanger international peace and security has become illegal. Thus, compulsive measures are lawful as long as they are able to maintain international peace. Intervention is therefore regarded as unlawful and is not justified. Now let's go have a quick comparative recapitulation of all our different laws involving ADR. There are different characteristics by which we compare customary law from national laws and international laws. First is on the governing laws. Customary law has the batasan or the customary practices of the group, which is deemed obligatory, whereas national laws refer to or is governed by Republic Act number 876 or the Arbitration Law, also Republic Act number 9285 or the ADR Alternative Dispute Resolution Act, also by the special ADR rules and the Philippine justice system. Now, for international laws, governing laws include international laws and various multilateral treaties such as the Hague Convention. Also included are the Hague Conventions for Pacific Settlement of Disputes, the UN Charter, United Nations Commission on International Trade Law, or the UNCITRAL. As to the symbolism, customary law has the balaghusay or the arbitrator as an important figure in the Talaandig community. Whereas in national laws, it is the Lady Justice, blindfolded and holding a set of weighing scales dangling on her left hand and a double-edged sword on her right. On international laws, it is the scales of justice, which represents the balance of the individual against the needs of society and a fair balance between the interests of one individual and those of another. As to the basis of the origins, the customary law of the Talaandig in particular bases its laws on the gugod or the Talaandig historical myths and legends. The national laws have the following as its basis: the 1987 Philippine Constitution, the Local Government Code of 1991, the Civil Code of the Philippines, the Revised Penal Code, among others. For international laws, the various multilateral treaties, the Hague Convention, and the UN Charter are among the basis of the origins. As to the framework or the models, the customary law has the agpangan or the patterns or models from the environment itself. The national laws have the Spanish laws, the United Nations or the United States Constitution and its laws, and other international laws. Whereas in international laws, we have the UNCITRAL Model Law, the 1907 Hague Conventions for the Pacific Settlement of Disputes, the Singapore Mediation Convention, and the UN Charter. As to the principles, the customary law has the common sense approach, the principle of interconnectedness and interdependency, the concept of balance and harmony between good and evil, the equality of God's creation, and the principle of avoidance and the principle of the wall and the shield. Whereas in national laws, it is the principles of justice and equity. As for international laws, the principles of justice, equity, and harmony among nations and the parties. There are several approaches in preventing conflict according to the customary law of the Talaandig. First is the pamalabag or pamagsa rituals, which define the boundary or limit as spiritual means to avoid conflict. The principle of avoidance and the principle of the wall and the shield. Also, the tampu dahu balagan or the peace pact traditions by the cutting of the rattan. There is also the means of the kagsaklulu or the traditional alliance to come to support, either to prevent, arbitrate, or to attack. There's also the traditional defense system through the alimaong, the lions, and the bagani, or the warriors. The food for peace, the parental leadership, the leadership accountability approach, the cultural impact assessment, and the intertribal agreements or pacts. In the national laws, the ways of preventing conflict involve the applications of the Constitution, Civil, the revised penal codes, and local government codes, the ordinances, IRRs, and other relevant laws. Whereas on international laws, the applications of international laws, various multilateral treaties, such as the Hague Convention and the UN Charter and the United Nations Commission on International Trade Law. Another characteristic is the concept of justice. Under the customary law, the gantangan or the measuring box and the timbangan or the weighing scale are the determining factors what is just and enough for the customary law. In national laws, it is based on sound and fair justice and equity, whereas on international laws, sound and fair justice and equity and harmony among nations and parties. Another characteristic is the settlement and resolution of conflicts and the laws involving them. In the customary law, the lagitip ha batasan or the payment of the large amount of goods before the resolution of a conflict is made. Another one is the saungangan ha batasan or to settle conflicts but demanding the lower penalties. And another is the right to retaliate by the offended party, which is within 8 days as permitted if the case has not been endorsed to the datuk for settlement. In the national laws, the ways of settlement include arbitration, mediation, consolation, early neutral evaluation, or mini-trial, whereas in international laws, it includes negotiation, inquiry, mediation, consolation, arbitration, judicial settlement, and resorting to regional agencies. In the application of justice or penalties, we have in the customary law the balaon or the trial by ordeal, such as hot water ordeal to determine the guilt of a person in case there is theft and murder. In the national laws, the applications of the Constitution, the Civil Code, the revised penal codes, the local government codes, the ordinances, the IRRs, and other relevant laws. Whereas in international laws, the application of international laws, including the multilateral treaties and conventions. Another characteristic is on the preliminary authorities. Authorities of the customary law include the tribal council or the council of elders. Whereas in national laws, they include the lupon tagapamayapa, the arbitrators, the mediators, conciliators, the experienced neutral evaluators, mini-trial panels, and of course the judicial system, among others. In the international laws, the Conciliation Commission, the UN Security Council, the UN General Assembly, the International Tribunal, the International Law Commissions, arbitrators, mediators, conciliators. The highest judicial or judging authority in the customary law is the datu or the tribal chieftain, whereas in the national laws, we have the barangay chairman or the Philippine judicial courts or the arbitral tribunal. And in the international laws, the International Court of Justice. As a conclusion, conflict prevention and resolution exists in every culture around the world. In the words of Dato' Migkitay Saway, tribal chieftain of the Talaandig indigenous cultural community of Songko, Lantapan, Bukidnon, it is just like the hands or the arms that are present in every human body. If every society and culture is given recognition and support in preventing the conflicts in their own society, conflict prevention will not become a global issue. Conflict prevention can be resolved using the existing models of balance and harmony of creation. Much more, it can be resolved by preventing further invasion and intrusion of others' rights, cultures, and territories, as defined according to the equality of God's creation. Conflict prevention can be more effective and practical through the use of common sense. It can be achieved locally and globally by letting the arms of peace in every culture hold together for the prevention of conflict in the world. As previously mentioned, the Philippines is currently actively promoting arbitration as an alternative means of dispute resolution between conflicting parties. And noteworthy also that the PDRCI and PICCR, or the Conflict Resolution and Mediation Agencies in the Philippines, offer online arbitration that Filipinos can avail. And in response to the current restrictions due to the coronavirus pandemic, they are reachable through their websites and their Facebook pages. Additionally, the Philippines is keeping itself abreast through the international trend in arbitration And with the introduction of new arbitral institutions such as the PICCR, enactment of laws allowing arbitration such as the revised Corporation Code and accession to the Singapore Convention, it is expected to become a credible and good option for arbitral proceedings soon. In general, the hopes that international matters should be dealt with the help of disputes resolution and not with political, economic, or military power still persists to this day. The use of military, political, or economic power is often viewed as failure of the international law, and which directly defeats the purpose of international law, that is peace and harmony. While in the perfect world, the use of law would be the means of resolving conflicts, but we know that in reality, such factors as military, political, or economic ability overpower the law. Nonetheless, law, and in particular customary, national, municipal, and international laws, can play a significant role in resolving disputes. Thus, we need to be realistic in acknowledging the diverse role of law in many dispute resolution, and at the same time, we should never underestimate law and its power, and we should be an advocate favoring the powerful potential of law. The following are our references for this research. Thank you for watching, everyone. This has been Insaluday, Lana, Saway, Sabuero, and Catherine Gabronino, JD3 of Liceo College of Law.